各位长官、贵宾以及我们线上的与会贵宾，大家好，大家早安！欢迎各位参与2021酷刑防治国际运作暨渔工人权专业论坛。我是今天的司仪 Rebecca。在民主、正义、多元、自由、平等的原则之下，台湾也逐渐落实人权立国的理念。而国家人权委员会为了接轨国际、促进交流，今天也特别邀请了国内外的人权专家举办专业论坛，针对专业领域来分享国际运作经验。那今天监察院院长兼国家人权委员会的主任委员陈菊院长也来到现场，院长非常重视这场论坛，我们现在就请院长来为我们致辞，让我们请欢迎陈菊院长。
谢谢。行政院罗秉成罗政务委员，那国家人权委员会高永成副主委，还有人权公约施行监督联盟。黄召集人黄老师、黄教授，辅仁大学姚孟昌姚教授，包括警政署刑事检察局我们的邝科长，还有各位关心人权的好朋友，大家好！非常欢迎各位参加国家人权委员会主办2021酷刑防治国际运作及渔工人权的专业论坛。国家人权委员会是在去年正式成立，我们运作10个多月。我们在既有的人权基础上，依据法定的9大职权，来积极拓展国内外人权合作新的方案。同时以社会各界来展开对话以及交流。我们为了要有效发挥系统性人权侵害的预防性的监督，以及法令政策总体检讨跟建议的前瞻的功能，国家人权委员会我们将完善来防治酷刑各项制度的建立。我们要汇整整个监察院外籍移工权利调查的案件，从整个国际公约来进行各面向系统性问题的检讨跟建议，同时提出国家外籍移工人权专案报告等等这些的工作，我们列入2021年策略计划目标中。因此，我们在今年2月开始筹划这一次的论坛，希望邀请国内外人权专家和关心反酷刑，包括关心移工人权的朋友，一起来参与研讨，同时展开对话。那很可惜，因为受到国内疫情升温的影响，在兼顾防疫的安全，同时要减少群聚的这个风险下，所以这一次的论坛，我们配合中央疫情指挥中心的规定，改为线上直播的方式来举行。虽然没有办法面对面的对话，
We would prefer to have face-to-face discussion. However, I think internet has provided us an opportunity for us to reach more participants. At today's forum, we are very honored to have speakers from Ombudsman New Zealand to share with us their multi-agency NPM model. Special thanks to Mr. Peter Boscher, the Chief Ombudsman of New Zealand. He's very busy. He cannot join us. However, he provided a pre-recorded video to greet everybody. In the afternoon, we will focus on the issue of fishermen's rights. The speakers include members of Control Yuan, consultant National Human Rights Commission, and also General Secretary General of Taiwan Association for Human Rights, and also representatives from the civil society. We will look into the working conditions, healthcare, and the social protection of fishermen, especially foreign fishermen. Taiwan is a democracy. We do not need to face the threat of torture. However, torture also includes cruel, inhuman, and degrading treatment or punishment. I believe torture also includes improper restraints and also any measures to deprive people's liberty. We hope that the implementing guidelines for the CAT will be passed at the legislative yuan very soon so that we can have the NPM in Taiwan. To conclude, I would like to thank all the frontline workers as well as the healthcare professionals who help us to fight this pandemic at this crucial juncture. We hope that we will be united to overcome these challenges. We keep the physical distance, but we are still closely connected with love and care. We want to welcome and greet the peaceful dawn which will come soon in the future. Once again, thank you very much for your participation. Thank you.
Thank you very much, Madam Chen. Now, I would like to invite Mr. Luo Bingchen, Minister with a portfolio and spokesperson of Executive Yuan, to say a few words. Ms. Chen Ji, President of Control Yuan and Chairperson of National Human Rights Commission. Mr. Yong Chen Kao, Vice Chair of NHRC. Dear speakers, dear panelists, dear participants and audience, good morning. There are two themes in this forum. The first is national preventive mechanism, and the second is human rights of fishermen. Actually, back in December 10th last year, the Executive Yuan has passed the draft of the Implementation Act for CAT. As mentioned earlier, this draft is being discussed at the legislature. According to this Implementation Act and draft, National Human Rights Commission needs to establish an NPM, National Preventive Mechanism, to stay in compliance with Article 18 in Paris Principle. And it is necessary to create a national level NPM. And the third passing hasn't become a reality, but NHRC has already started some efforts. This forum is one of the examples of these efforts, and Control Yuan and the Executive Yuan are also already discussing a possible NPM in Taiwan. So in that regard, I really admire NHRC for taking this important responsibility to create an NPM. However, this is only a very beginning stage for NPM in Taiwan. There are a lot of discussions to be made. We also want to learn from our international friends. So I'm really happy to see that NHRC in Taiwan is able to organize a virtual forum like this one. I think this is going to be a very meaningful event. I'm sure that we will be learning some practical practices in terms of NPM and in protecting the rights of fishermen. As I said earlier, another theme of today's forum is fishermen. Taiwan is an island, and the fishing industry is very important to Taiwan. The fishing industry has hired many migrant workers on their ships. As this industry develops, there are more and more human rights issues that we need to pay attention to, especially for migrant fishermen. They face some human rights issues. And NGOs in Taiwan and in the international community have been followed up with this issue and provided their recommendation to the Executive Yuan. On December 10th last year, as I said, the draft of the Implementation Act for CAT and OPCAT was passed. On the same day, the Executive Yuan also passed a guideline for a business, meaning that businesses also need to take human rights actions. With such a project to encourage businesses to protect human rights, the Executive Yuan is working with its Council of Agriculture and Agency of Fishing Industry to co-develop a draft project. So we want to use this opportunity to thank human rights experts and NGOs in Taiwan for your recommendations. And through the action plans for fishing industry and human rights, I hope that we'll be able to respond to the expectation of the society to provide better protection for migrant fishermen, to have better labor inspection, higher incumbency, to create a better FOC mechanism, to have better management for agencies. So I really look forward to proactive sharing and exchanges so that the executive branch of the government can learn from you to have some good ideas and to continue to provide better protection for the people who are in the fishing industry. Let's work together. Thank you very much.
Thank you very much, Mr. Lo, for doing this online. We also have international speakers. We will say hi to everybody, so that's welcome. Ms. Ruth Nicole.
Hin hao, Dana koutou katoa. Good morning, everyone, and welcome to your wonderful conference that you have set up. I'm sure you're all going to have a wonderful experience. It is a pleasure to be with you. It is very pleasing to learn that you're about to embark on your examination of treatment and conditions of people detained in childcare and youth justice facilities. This work, this human rights focused work, is an absolute privilege to be working in, and I encourage you in that work. I wish you well for your conference. Thank you.
The Chief Ombudsman Peter Bosher from New Zealand will also join us via pre-recorded video. And Peter Bosher is a senior judge in New Zealand. So there's play.
Ni hao, kia ora, and my warm greetings to you all. I'm Peter Bosher, the Chief Ombudsman for New Zealand and the President of the Australasian Pacific Ombudsman Region. Some of you may already know me from my first visit to Taipei in 2018, or when your office hosted the annual APOR conference in 2019. And so I greet you all again virtually. I must congratulate you. The recent establishment of your National Human Rights Commission and the upcoming launch of the NPM are immense milestones. Thank you to the Control Yuan for reaching out and inviting me to be part of this forum. I value the relationship between us, and I see today's initiative as a real illustration of that. I wish to convey my apologies for being unable to attend today. Presenting in my place is Dr. Ruth Nichols, who is my principal advisor on OPCAT matters, and I'm sure her presentation will be of value as Taiwan heads towards launching its NPM this year. I wish you all the very best for today's forum, and I look forward to continuing to work with the Control Yuan and the NHRC in the future. Chia, chia. And as we say in New Zealand, e noho rā, goodbye.
Thank you very much, Mr. Bocher. Now we are moving to the first presentation, NPM experiences. So I will give the floor to Vice Chair Gao Yongcheng of NHRC Taiwan.
Ladies and gentlemen, good morning. And I would like to say greetings to all of you and Dagay Ho, which is Taiwanese in meaning good morning. So I am the moderator of this session, which is about the NPM in New Zealand. However, I need to apologize to all of the participants because according to the original agenda of today, we have arranged two consultants from New Zealand Human Rights Commission and Ombudsman New Zealand to give their talk, but due to some unexpected events, they are not able to present in these virtual events. But in December 2018, I myself went to the Auckland chapter of New Zealand Human Rights Commission. And that was also the time when Taiwan was about to start our NPM. So I had some initial exchanges with them. So later on, I will be the one to share some New Zealand practices. I think other panelists who are with me right now also have some understanding of New Zealand's NPM, so they will be sharing their understanding. So my apologies first. That's the two representatives from New Zealand's Human Rights Commission and Ombudsman are not able to deliver their presentations with us. Yet we have a very strong lineup among our panelists. So allow me to give a brief introduction of them. The first is Professor Mengchang Yang. He's currently the assistant professor at Furen School of Law. And he has a Doctor of Laws from University of London and Master of Laws from the University of Edinburgh. And he used to be a member for the implementation team for the incorporation of CAT. And he was also a member of, or is still a member of Committee on Consultation at Control Yuan. Our second panelist is Professor Song Li Huang, the convener of Covenant Watch. He's a professor at Yangming University, and he has a doctorate degree from Harvard University. He played a very important part as a consultant to the establishment of the NHRC in Taiwan. And right now, he's a convener of Covenant Watch and an active participant in all kinds of conferences on CAT. Our third panelist is Mr. Kwang Chin-tai, Director of Criminal Investigation Bureau from National Police Agency, Ministry of the Interior. He has a master's degree from Yilan University and a bachelor degree from Central Police University. And because his department is in charge of the implementation of CAT, so I think he is one of the best candidates to talk about this. I think this Saturday marks the 34th anniversary of CAT UN. And there is that will be also a special day to support the victims of the cruel treatment. Despite the pandemic, we are still able to discuss how to implement effective NPM and how to mainstream the idea of protecting the rights of the victims or potential victims of cruel treatments. And as mentioned earlier, we now have some pilot projects already. We have invited an expert from Czech to discuss their experience in implementing NPM. And we have an NPM task force already to design the items that need to be exempt when going into different institutions. And we also want to devise a checklist. And we want to invite experts in various fields to jointly conduct such an examination so that we can prevent cruel and inappropriate treatment. This is a national project of NHRC, and NHRC has passed this annual project already. And when the pandemic has improved, I think in later this year or the first half of next year, we will officially start these projects. New Zealand had the NPM starting from 2007. They have a model which is multi-body at NPM. It's been 14 years since their NPM was established. And I later on will briefly share with you my limited understanding of their NPM. But I think we will also learn from our panelists today because each of them will talk about the essentials for NPM and the structural design of NPM and the planning and implementation of NPM in Taiwan from the perspective of foreign practices. So I really look forward to the sharing of the three panelists. Now, without further ado, I would like to start the ball rolling by sharing my experience I had back in 2019 when I visited the Auckland chapter of New Zealand's Human Rights Commission. We did pay special attention to NPM in New Zealand, so I will talk about that. In addition, I also went to visit an Auckland prison. I will also share that experience too. Okay.
As I said earlier, NPM in New Zealand is a multi-body, multi-agency model was centered around the National Human Rights Institution. We will go back to this slide later. In our 2018 visit at that time, the control yuan did not have the NHRC yet. So the trip was to learn about the practice in New Zealand, and of course, the update on the NPM experiences was also included in our trip in our learning. They have the 5 members of the NHRI, and they have 3 chapters in Auckland, Wellington, and Christchurch. 3 offices. They have around 50 to 60 staff. They also have independent human rights proceedings office. This office is helping the victims, providing the bona fide legal consultation, and that this is in line with the Paris principles. This is the grade A, level 8 NHRI, so the functions and the practice of New Zealand's NHRI in line with Paris principles. They also ratified the OPCAT in 2017 and designated the central NPM, NPM, that's the NHRI. They also have NPMs. And since this is a multi-body model, and they work independently, but they also collaborate together. And NPM is playing a coordinating role to provide a report and investigate those institutional cases. They also work on international collaboration and cooperation with international organizations such as United Nations. Let's go back to this slide. You can see that these are the 4 agencies. Ombudsman New Zealand, responsible for inspection, and also you can see they can visit the elders' care home, and also immigrants and their children places of detention that can include so many different facilities. And also there's another agency, Independent Police Conduct Authority. They will inspect police custody. Another agency is the Children's Commissioner. They are responsible for inspections for those children's care, including remand care facility. And also, you can see another one is Inspector of Service Penal Establishment. That's for the Defense Force. And NHRI, that's NHRC of New Zealand, is at the center. It is the NPM. This is what we learned from the trip. We learned that New Zealand has adopted a multi-body mechanism, and NHRC is the coordinating agency. And it is also contact point with international organizations such as United Nations. You can see that it also works closely with the other agencies to conduct joint inspections. But usually these inspections are not initiated by the NHRC. They also have the international human rights experts to conduct assessment. And after inspection is completed, NHRC will provide reports and records indicating that the strengths and also some of the weaknesses or drawbacks in these facilities. By doing so, they provide recommendation on enhancing human rights. The budget is from the government. All these are independent agencies. Ombudsman New Zealand also need to report to the Parliament that it is an independent institution. It has to report to the Parliament on a regular basis. So HRC still need to answer to the general public of the New Zealand. So this is a very special model, multi-agency model. The question is whether or not there will be some overlapping of responsibilities. And during our trip, we learned that this is NPM. That means prevention is more important than the ex-post punishment. There indeed is some level of overlapping among these agencies. For example, the prisoner gave birth during serving her term. The Ombudsman office need to conduct an inspection with other agencies. They followed the principles of continuous talking and working out the principle to achieve the consensus. This is a unique model. Sometimes it takes a lot of time, very time-consuming, but they always can come up with a solution. This is a necessary process to reach a consensus, accumulating the value of the society. The external pressure from the United Nations also becomes a positive pressure to New Zealand. Safeguarding human rights is a national policy. I think in Taiwan, we also believe so. United Nations will send delegations to review and assess the outcomes under the major international human rights convention. And after their visit, they will write a report, including the suggestions for New Zealand. NPM is a mechanism that, for regular inspections that produce recommendations through the coordination of multiple agencies and through communication and consensus building to improve the condition of treatment of the site of the detentions and the detainees. So that this is a preventive perspective to reduce the likelihood of human rights violation. We came up with some of the questions during our visit. Well, NPM asked the facilities to make corrections. They responded by saying that before they issue the official report, they will talk to the facilities they inspected, listen to their feedback. Such a model is to make NPM more open and transparent. the general public can understand that the process of implementing these international covenants. How about the effectiveness? Well, since 2017, after they ratified the international covenants to these site detention, maybe some improvement was not immediately seen, but the experiences is that the recommendation or suggestions were very well taken. And also some the specific cases of improvement could be made through communication and coordination. So it takes some time to move the country to a better direction to materialize these universal human rights values. And also they have the Ministry of Justice plays a role on NPM and OPCAT. The ministry say that they are only responsible for legislation and also any amendment. They will not do the actual inspections. What they can do is to come up with the amendments to the legislation based on the reports to come up with solutions. We also asked the question, is a multi-agency model better or the single NPM model better? They said that they actually signed in 2003 on CAT, and before 2003, these agencies had been functioning well. Take Ombudsman Office, for example. The office is tasked with ensuring the public agencies can improving and function better. So the responsibility of these agencies are very different. But keeping such a multi-agency model also bring the diversity to the implementation of these international covenants. During our visit, they told us they never thought about streamlining the NPM model, and if this is just one agency model, maybe it is more efficient because we assume that it takes more time to coordinate multiple agencies. But then if these multi-agencies can work professionally and provide more perspective, that's actually a plus.
While working with the different institutes, I think each mechanism or each institute can learn from each other. So New Zealand consultants think that its multifunctional NPMs are working well. They still have reports, and the results of the reports show that they have reasons to be satisfactory with NPM. So we visited the Auckland chapter. We learned from their practice in terms of NPM very briefly. Moving on, I want to talk about my experience during my visit to the Auckland South Corrections Facility. As a member of the Control Yuan, I have visited many different correction locations in Taiwan. But this was my first experience with a foreign correctional facility. It had a very special design and structure. In 2015, this facility was completed with 300 million New Zealand dollars, and Circle Group was commissioned with the operation of this facility. The contract will last 25 years. This facility, ASCF, and an area of 17 hectares with 13 buildings. Department of Corrections in New Zealand decided the design of the facility, but the operation was commissioned to Circle Group. And in considering New Zealand's culture, Maori's culture, and so on, their operation is not what we expected, because what we witnessed there was things like a dormitory, and the inmates had to care for their own lives. They cook, they did their laundry, they discussed their budget. They could also use the computers, but without the internet. They had their own financial account so that they can receive money from their friends and family. They don't have to conduct some labor project, but they can voluntarily do some labor work and get some payment for their work. And of course, there's a limit of how much money they can spend. It's about 70 New Zealand dollars. And of course, this facility has to be compliant with their Criminal Corrections Act from 2014. And Circle Group has to provide monthly, quarterly, and annual reports on the performance of the inmates and how these inmates are reconnected to the society. So there are supervisors, there are also ombudsmen which supervise this facility. I cannot show you the pictures of the facility because our phones and cameras needed to be locked away during our visit. The vice director of the facility accompanied us throughout our tour. I want to move on to my next slide. Can I do that? Would you please help me move to the next slide? Okay. They have a culture center in the facility. Yes, this is the picture of the culture center built based on the Maori culture. There's another culture center, but this is the Maori's culture center. And the crime rate is a little bit higher among the Maori population. So in order to cater to the indigenous culture, the facility includes such a building within their establishment. Back in Taiwan, people may think that it's almost impossible to imagine that the treatment of people within these facilities is better than the treatment of the general public who are free in the society. And as I said earlier, this facility looks like a dormitory. Men and women are separated. They have a kitchen. They can use knives in the kitchen. I think this is a human right-based management because the society looks forward for the integration of the inmates after a while. And it was expected that most of the inmates will be back to the society and have their lives there. So management-wise, it provides more freedom and liberty to the inmates, but the basic living needs are all satisfied. And this is part of CAT, I think. As I said earlier, this design caters to the indigenous culture and the management, and the philosophy there is human rights based as well, because when these inmates return to the society, they will be able to contribute to the society. If we take on this perspective, and then I think we will be able to find our shared and common values on NPM. And I also visited more than 10 Taiwanese inmates in this facility. They all say that the management of ASCF facility was very good. However, they were also concerned that whether or not they have to finish their sentence in Taiwan. Maybe they have to, but at least their treatments over there in this facility appears to be satisfactory. So if there are some participants from correctional facilities in Taiwan, I would like to share this with you especially. When we visited correctional facilities in Taiwan, we saw foreigners too, and these foreign inmates will complain to us about the treatments. And the first concern is health insurance. They are willing to pay for their national insurance, but it is currently not allowed. So they have to pay out of their pockets without any national support. So that's one of the complaints. So we met Taiwanese inmates on Auckland, and we met foreign inmates in Taiwan, but they gave us very different feedback. So I think there's some improvement required in Taiwan. So this is my brief introduction of an NPM in New Zealand and the visit at an ASCF. So moving on, I would like to invite our next panelist, Professor Yao. I would like to thank the Control Yuan for inviting me to be here, and it is my pleasure to meet with friends from New Zealand and experts and participants from Taiwan as well. Today, I want to talk about the essentials for the NPMs. First of all, allow me to show this slide. This is in a museum in Auschwitz, Poland. You can see glasses, shoes. But do you know who used to own this artifact? Move on to the next slide. This is the best film in 2016's Berlin Film Festival, The Road to Guantanamo. This victim is a victim of torture. Where was he from? How did he end up here? What did he do that he deserved this treatment? How long had he been there? And what was his future? Will he be treated fairly and tried fairly? We see none of that information. The only information we see is B-54, a label, but there's nothing else to identify such a victim. So we are against torture because we are against any act that dehumanize people. If a person is dehumanized, then the people in the community in different ranks, in different regions will be dehumanized. And then what we see is ethnic cleansing. So unfortunately, we need to look at this reminder seriously. Torture has been always in our history as a human race. When human beings meet others, these others may be family or friends or other strangers. As long as there are cases of meeting other people, it is possible of torture. Torture can be anywhere. It can happen at any time. But a nation plays a very important role here because the nation may conduct the most serious violation. And these violations are in fact performed by the country. If we are not able to change that national practice, if we are not able to change the mindset of the people who have the power, then we won't be able to prevent torture. So we want to protect people from cruel treatment or degrading or inhuman treatment. And CAT and OPCAT were created to show to the world that we need to treat torture as the most serious disease in the world. It has to be eliminated. So people who engage in torture needs to take the responsibility, and he or she needs to be sanctioned. How do we know there is torture? Well, there should be a mechanism for people to understand what's happening in the places of detention. So when we discuss torture, it's the responsibility of every individual and every country. So universal jurisdiction principle states that every act of torture needs to be followed up and punished. Now, speaking of NPM, I think it has a lot to do with several important international human rights instruments. There is UDHR and ICCPR from 1967. And in Article 7, 8, and 9, as well as Article 14, Article 27, Article 2, and so on, all mention elements that are related to anti-torture. I have to stress that torture may not be addressed to one individual. It can be addressed to one religion, one culture. And CAT from 1987 and 2006, OPCAT. So these are the several international instruments. From this map, we're seeing 80% or even 90% of the countries have ratified CAT. And since I teach international law, I think whether or not we join CAT, we need to treat CAT articles as international customary laws. We have the obligation to follow it. And OPCAT doesn't have that many signatories, and you also impose more responsibility on state parties, and that's why many states don't want to ratify it yet. But among all international instruments or conventions, countries can have reservations, but optional protocol requires all articles to be followed. There shall not be any reservation. So today, we talk about the practice in New Zealand. They ratified CAT in 1989, and UK joined OPCAT as well, and Canada signed OPCAT but has not yet ratified it. So various countries of the world are at the different stages when it comes to CAT and OPCAT. But are CAT and OPCAT related? of course, they are very relevant. Upon signing OPCAT, a country is reviewing whether or not this country has fulfilled all the obligation under CAT. So if our country want to fulfill our obligations under CAT, I think it is necessary to ratify both CAT and OPCAT. And OPCAT is very special among all international instruments because it says that state parties have to be proactive. Just like the optional protocol 1 for ICCPR on individual complaints and on death penalty. It seems that state parties are given more reactive responsibilities, but OPCAT impose these active responsibilities on countries, and therefore the role of the country is bigger. And the most important purpose is to shape the human rights culture. So my topic today is essentials for NPM, and many of you will talk about procedure and personnel and so on. But I want to stress one thing. From reading the subcommittee of torture, inspectors will also go to different countries such as Austria and so on. But when the team goes visit, they say that when an NPM is not recognized or accepted by the public, or is not clearly identified by the public, this NPM is not effective at all. So, national preventive mechanism is a test stone. It tests whether or not the society is truly promoting and respecting human rights. And in the interest of time, I will use this slide to show you the different articles from OPCAT. Article 1, 3, 4, 17 to 23, 30, and 35 all mention NPM. You can refer to my slides. But I want to stress that the implementation of CAT and OPCAT has to be performed at the same time. We may see cases of torture in places of detention, and therefore the government has the responsibility to examine these locations. So I think it's important to have NPM, and NPM is very important to the implementation of CAT. And while creating NPM, do we have to follow the guidelines on national preventive mechanism from the UN? If you review the optional protocol, it's a living document like other UN instruments. So if you see the optional protocol from 2002, you see the documents stating the criteria to prevent torture at that time. But if you look at guidelines on national preventive mechanisms and other soft laws, you will realize that the criteria has become higher. So one example, well, CAT states that the country has to make a regular visit to go to correctional facilities. But in the guidelines or in following standards, we see that unannounced visit is stressed. So the intensity and the frequency of the visit have to be elevated. So the state parties need to invest more resources. But can HRC play as an NPM? Well, I think other panelists will talk about it. I myself don't have a conclusion. But we do see that UN cares a lot about whether NPMs are independent funding and independent personnel. They need a lot of these resources, and their work is continuous. NPMs have to make continuous visits. They have to be proactive. Their work is preventive too. So compared to NHRCs, NPMs are more active and more positive. So if NPM is under NHRC, well, then I think the intensity or the powers of NHRC has to be strengthened. Otherwise, it will not be able to fulfill the responsibility as an NPM. So I think my point here is about our implementation acts of CAT. In our implementation act, it is really important that it is in line with the guidelines on national preventive mechanism. So when I joined the drafting of the Implementation Act for CAT, I and my team believe that the guideline has to be part of the Implementation Act. And what laws or regulations should be created? Well, this slide of mine shows that NPM's composition, functions, powers have to be specifically stated in the law. Well, the control yuan has speech immunity or had such immunity, not anymore. But NPM's personnel needs some privileges or immunities. So, well, actually, I'm going to skip the guidelines here. Instead, I want to state that the life of a system is not only about logic, it's also about our experience. So we need to learn from other countries' experience, like New Zealand or Austria or Germany. Austria's population is 8.6 million, and it covers 850 or so square kilometers. When UN's team went to visit Austria, UN's team says that you don't have enough personnel in your visits, and your functions, your powers are mixed up, and you're not able to fulfill as an effective NPM. So for more details, you can refer to my slides. So my point is that even advanced countries such as Austria and Germany have encountered some challenges. It can be expected that we will encounter challenges as well. I myself think that the members of the NPM are extremely important. They have to have exercise. They need to have the courage. They need to be persistent. So their character is important. Second, can the people support and identify with NPMs? Now, everyone thinks human rights is the right thing to do. But how about NPMs? If we tell the general public that, oh, NPMs may protect the rights of the inmates, they may protect the rights of the foreign fishermen in the fish industry, people who don't know, people who we don't know whether are good or bad persons. The general public may become indifferent because they may feel they're really distant from these people. So if the general public do not understand that it is necessary to protect the human rights for everyone, even the so-called bad people in the prison, if the general public do not have such consensus, then NPM will never be able to be effective. And also, the organizational culture is also really important. Some people from correctional facilities will tell me that what you teach is an ideal, but what we have to practice is reality. So there's a gap. The fourth point, it is important to have good allocation of personnel, finance, and administration. There are so many correctional facilities, nursing homes, and custody locations for young people. There are more than 2,000 these kind of facilities. There are dozens of thousands of people in these facilities. How do we plan regular visits? It's going to be challenging. I think Mr. Gao, the vice chair, said that this Saturday is a day to support the victims of torture. So let me show you this picture. This is a very old prison. But what differences do you see in this prison? It's full of light, and the doors are all open. It's very old, but you don't feel that this is a dark place with death. I think that the result that NPM can generate, and Churchill said that the mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. So lastly, I would like to show you this picture. This is a picture taken from a museum in Glasgow. When we look at this, we think of Jesus on the cross. But did this picture says that this is Jesus? Do you see the sparks? And do you see the lashes or the injured ribs of this person? So how do you know this is Jesus? But this picture says to us that if we're able to put Jesus on the cross, it means that anyone or everyone could be put onto the cross. You or I could be the one who are put on the cross. So when we don't really feel what torture is, we feel NPM is just a formality. So we have to really relate ourselves to NPM. Thank you very much.
Thank you very much, Professor Yao. You just touch on the key point for us to remember. And of course, the competent authorities will need to work hard to have a sound legal basis, as well as factor in international practice. All of these are very important points from his presentation. The persistency of the competent authority is very important. So let's move on to the second discussant, Professor Huang Song Li. Thank you very much, Vice Chair Gao, and my fellow discussants, ladies and gentlemen, good morning. In my presentation, I will speak about the organizational design of national preventive mechanism. If you look at the implementation act on CAT and OPCAT, we see that there are the two possibilities. The NHRC or the control yuan could be the agency responsible for NPM. But the NPM is very different from the conventional ombudsman functions that include investigation, censure, impeachment. NPM is more focused on discovering the problems and also guiding constructive dialogue and facilitate problem solving. So the preventive function is very important. So the oversight body who also have the responsibilities for the ex-post accountability and receiving complaints, then maybe that's not really prevented the model. If you look at the monitoring inspection visit conducted by the control yuan in terms of the type of the facility, frequency, and also the purpose. And while there are many differences from what is required under the OPCAT. That's why that we need to have a new organizational design to factor in the requirements of the OPCAT. As Professor Yao just indicated, in designing NPM, we need to study, analyze the requirements under OPCAT. Mention the independence of NPM, and also the site detention to be inspected or need to be selected, and also the agency responsible for NPM need to have sufficient resources. So I think there are the four issues we need to think about. The first question is whether Taiwan will have the one NPM or multiple NPMs. If you read the Article 17 of OPCAT, one NPM or multiple NPMs, both can be adopted and accepted. And the question is whether or not we have sufficient resources. For the NHRC, you will need to review the staffing, whether or not it has enough staffers to conduct NPMs. The organizational structure of the NHRC, if we review that, the resources could be a big issue. Another issue we have to consider is be it single or multiple NPMs, we need to decide the frequency of the inspections for facility, for example, facility covered under NPM, and we also need to review the qualification and level authorization of inspectors. Are there any trainings we need to provide to the inspectors? The second question on the design of NPM is about the independence of NPM. We can refer to the Article 18.4 of OPCAT. When establishing national preventive mechanisms, state parties should give due consideration to the principle relating to the status of national institution for the promotion and protection of human rights. That's Paris principle. If you designate NHRC as an NPM agency, that actually that means that we will have NPM decide in the organization or structure of the NHRC. If the agency has other functions, then the independence of NPM that need to be designed. OPCAT does not require any legal basis. However, SPT indicates in several paragraphs that the legal basis of the legislation for NPM is required. Good example is New Zealand. Other than CAT, we also need to have NPM Organic Act as well as NPM Power Exercise Act. In Taiwan, we have this very unique structure. We have the Control Yuan, NHRC, and the NPM. So you might think that we will have the model on the left. However, we need to respect the fact that these three organizations all state agency, and these three organizations have their own organizations, structures, organic act, and they also played different roles, fulfilling different functions. Well, to avoid misunderstanding, so that to the outside, we need to have the different recognition on the roles and the function of these three organizations. The third question, how can we benefit from experts? The role of experts in NPM. We need medical doctors, nurses, psychologists, and also specialists in the physical and mental trauma, the diagnosis, assessment, and the treatment. We need all these experts to join our team so that we can provide services to the detainees. We may also need legal experts. In such a process, we do not have these people. If you look at the current organizational structure, there's a way for us to enlist external experts, or we can also work with other professional groups. This is something we need to think about in establishing Taiwan's NPM. The worst way to organize a team on the ad hoc basis is better to have a long-term partnership with experts from different groups with these outside experts. Because these experts probably will need to join us on these inspection trips very often. So I think that this should be included in the Organic Act of NPM and also the Power Exercise Act of NPM. The fourth question is how can we operate a multi-body model well, like New Zealand, as Vice Chair just indicated. They have the four agencies collaborating in their multi-body model. Well, other than the police inspection, the Ombudsman Office initiated most of the inspection. If Control Yuan play some role in the NPM, then Control Yuan need to establish a dedicated unit responsible for NPM. So to the outside partners, they represent Taiwan's NPM. They do not represent Control Yuan or NHRC. Another question is how NHRC can play the coordination role. There are some examples internationally we can study, considering the multi-agency model. Sometimes we designated one agency be it the police, the oversight office, or the National Defense Supervising Office. And this agency has its the original functions and the mandate. If you designate that as a part of NPM, that means NHRC will direct these agencies in implementing NPM. Under such a scenario, how can we make such a model still function well and with the level of independence? So the work model and also the command from NHRC is an issue we need to think about. The very complicated interplay between the control yuan, NHRC, and these other agencies. When we talk about the multi-body model, we also need to think about the relationship between NPM and the Parliament. It is stated under Article 19 of the OPCAT. NPMs actually can provide recommendation for future legislation or amendment to the existing laws. It is easy to do this with a single agency model. Multi-agency model then seems to have some difficulties in coordinating these issues with the Parliament to win the approval from the Parliament. Another thing I would like to remind you is that many people think that NHRC has soft power. It does not have the hard power like censure or impeachment, but soft power is not weak power. OPCAT Article 20 NPM need to exercise a lot of powers. All these are hard powers. Then, for example, restricted access to all these sites of detention. And the results based on these inspection trips, NPM can provide recommendation to these facilities. So it is soft power, but it is not weak power. So a good example is the practice in New Zealand. I really hope that, like New Zealand's the Crime of Torture Act, Taiwan should also have a similar law. And while the one agency or multi-agency models both have their challenges in terms of independence, systemic inspection resources, expertise, and relations with the Parliament. We need to have the effective preventive model to exercise the soft powers. Thank you. Thank you very much.
I think this is a really good guide for NHRC and the legislature when drafting relevant laws. For example, the functions of NPM needs to focus on prevention and on organic design. I think Professor Huang gave us really good ideas. According to OPCAT, NPM has to be independent. Its organization and system has to be independent. Now, according to the Implementation Act, NHRC needs to create a dedicated organ. So Should we create another independent division under the independent HRC, and this unit needs to have independent personnel or funding? I think these are things we need to consider while making the law. At the legislature, further discussions will be needed, and so does more coordination. Finally, you talk about how to effectively implement NPM. Yes, that's important. So thank you very much for your suggestions. And before Mr. Kwong will give his presentation, I want to remind the organizing committee want to remind you that you can leave your questions or comments online, because later on there will be a Q&A session. Now, Mr. Kwon, you have the floor. Mr. Moderator, my fellow panelists, and dear participants, online and offline, good morning. It is an honor and a pleasure to receive the invitation from NHRC, so I can be here at the Forum on International Practice of OPCAT and NPM, as well as human rights of fishermen. I'm here on behalf of the Ministry of Interior, and I would like to talk about our NPM from the perspective of international experience. Now, that was my outline, and moving on. We had received the recommendation that it is really important to implement CAT. And the Ministry of Interior, especially National Police Agency, which is my agency, organize many hearings and meetings because we are the dedicated organization in charge of CAT in Taiwan. So we decided to use Implementation Act to promote CAT. So I would like to thank Control Yuan, Professor Deng Yansen, and many teachers from the University of Police. In 2020, December 10th, the Executive Yuan passed the Draft Implementation Act. And in December 18th, the same year, it passed the first reading. 3 subcommittees, including National Defense and Interior Management and Judicial and Legal subcommittees review this draft together. Now, I want to talk about some important articles in the Implementation Act. There are 10 in total. First, the purpose. Second, give effect to it as if it is domestic laws, and we refer to UN documentation, and different government agencies need to fulfill their responsibilities. There is article about national reports, human rights education, prioritize funding, regulatory review, and the date of implementation will be determined by the Executive Yuan. And Article 5 is about establishing a dedicated NPM. So Article 5 states that Control Yuan's National Human Rights Commission will create a dedicated NPM. In the currently planned NPM, we know that OPCAT says it's important to have a national level NPM. And Article 17 of OPCAT says that after or within 1 year after the state party signed and made the OPCAT effective, then it has to create an NPM or NPMs. Our original plan was to put NPM under Control Yuan. But NHRC under Control Yuan has been created and is in operation, so we changed the original draft. We want to put the NPM under NHRC. And the functions of NPMs are really important. These functions do not include receiving and dealing with complaints. Its emphasis is on prevention and examination. And HRC also has a power to examine. So we need to think how we can coordinate these efforts. This slide shows you briefly the NPMs adopted in New Zealand. I think Mr. Gao and the other two panelists mentioned this already. New Zealand has multifunctional model. It has a central NPM, and then there are 4 other NPMs which are dedicated to different aspects. New Zealand's Human Rights Commission is the CNPM. It helps coordinate different NPMs. This is a different model from our plan in Taiwan. However, this is a model which includes multiple functions or multiple institutes. This is a good reference. We can learn from the New Zealand practice. For example, these different NPMs have independent functions. There is a great diversity of experts. There's gender equality, and these models represent the minorities too. It has independent functions and diversity among an expert. I think these 2 attributes are really important in our design. When experts and scholars discussed NPM in Taiwan, they mentioned that Article 18 of OPCAT says that the state parties have to make sure that NPM has independent personnel and independent functions. And state parties also have to take necessary measures to make sure that the experts have necessary expertise and knowledge. And this is our direction too. We want to follow these guidelines and to create an NPM or NPMs that are in compliance with international standards. The draft of Implementation Act is still being reviewed in the legislature. But the Judicial Yuan and the Defense Departments, Education Department, and Fishing Council, and so on, many industries and agencies are involved and in CAT. So we need to start coordination early. So National Police Agency under Ministry of Interior want to help coordinate. We organize hearings. We have research projects. We ask scholars to help review the laws and regulations in Taiwan so that after the Implementation Act is passed, we'll be able to start the official review of the laws. We organize education, trainings, and conferences. We hope that civil servants at different levels will understand the philosophy of CAT. In the future, we will also organize more courses so that the public workers will understand how to make sure that their work, their practice is in line with CAT. We will also continue to organize promotions, use different channels to help the general public in Taiwan to understand the spirits of CAT so that they can truly support the development of CAT in Taiwan. And another part of our job is to draft state reports and organize international review meetings of our state reports. In 2008, 9, and 12, we organized academic conferences on CAT. So I want to thank Control Yuan for your great support. Especially, there was one conference last year where the President Chen Ju came to give remarks, and many members from Control Yuan and HRC came to share their thoughts too. So our National Police Agency will do our best in making CAT part of our domestic law. Thank you very much.
Thank you very much, Mr. Kwong, for your sharing. He reminded us the key points of the Draft Implementation Act. As Professor Yao just indicated earlier, the key actually lies in the human rights culture in Taiwan. And we are very happy to then that at the Ministry of Interior, you have conducted so many training sessions, and also you talked about the importance of reviewing the existing laws. And we look forward to working closely with you in the future. Such a culture that needs to be in every part of our society. So we just listened to the sharings from the three discussants on behalf of NHRC. I would like to thank you for your insight, reminders, design of the organization, and also you raised a lot of very good questions. And all your reminders will be put on our records. Thank you. So let's move to the Q&A session. Thank you very much. Thank you, Moderator Vice Chair Gao. Since this is online, the forum, we do receive many questions from the online audience, and we will project the questions on the big screen. We have a little bit delayed. We have around a little bit more than 10 minutes for the Q&A. So once again, I give the floor to Vice Chair Gao. The first question is for Professor Yao. You talked about being approved but not joining. What do you mean by that? I think you mentioned Canada in 1987. They ratified the CAT, but actually Canada does not join the CAT. So it is not a state party. So the point is that a nation can express its position. The country can also decide not to have the NPM. If you look at the mechanism of the United Nations covenants, the original design to have the CAT and then NPM in one single document, but now we have two separate documents. And for any state party that you have to sign these two documents, you also need to have specific implementation act, including the Domestic Power Exercise Act. I think that's the point. It really lies in the human rights culture of a society. To implement NPM, you need to have both documents. Different countries have different cultures and practices. Some countries haven't ratified these conventions. Maybe they are still given the society to adapt to or to accept these new standards. As Professor Yao just indicated, you need to have an implementing act incorporating this spirit requirement of these two documents. So both are required. So that's the response to the first question. The second question is for Professor Huang. Professor Huang, you talked about experts' involvement in NPM is very important. How can we attract those experts in the medicine or public health to join NPM? So, any special reminders in listing these experts? Thank you very much for the question. Let me say that experts can work at two levels. So NPM has members or commissioners or on the working staff. So at these two levels, we can benefit from the involvement of experts. So the one way is to enlarge the organization. We can also ask the government to give us more funds. And secondly, if we want to work with outside experts, it's always the best to maintain long-term partnership, since this is a thankless job, and because they need to go on inspection trips very often. So to attract experts to join us, number one, the compensation need to be attractive. Maybe experts do not think that's the most important consideration until most people who want to do things like this, and many because they do have the sense of mission, including the recognition of what they are doing in exercising their power, and also the actual effects coming from what they do. So we can enhance the sense of mission. We respect their powers, plus good compensation. I think we can attract some experts. However, I would like to stress that to deal with physical or mental trauma cases, we really need experts in medicine or the psychology. For detainees, especially long-term detainees, they are different expression of their traumas. That's why we need a lot of training and also the help of experts. Thank you. Thank you very much, Professor Huang. Last night at NHRC, we actually conducted a session that was an online session on coordinating the different agencies. Since this is the trial plan, we are still learning, and of course, this friend just touched upon this very important issue. We want to attract experts to join us, a lot of practical consideration, including compensation. Well, we do have a talent pool, which include many candidates. We hope that we can build up this talent pool. If the friends who join us online know anybody, please also let us know. And training is very important. This is not an issue we have to address. After we have talent pool, such a database, I believe we have a lot of the experts who do have the sense of mission and would like to join us to implement NPM in Taiwan. The third question is for Mr. Kwang. you talked about New Zealand's NPM. You talked about the gender balance. Could you talk a little bit about this and also the collaboration with the police agency? Thank you very much, Vice Chair Gao. And also thank you very much for this question. On gender equality for NPM, it is actually under the Article 18 of the OPCAT. We need to consider the area of expertise as well as gender balance or gender equality, as well as the ethnic equality, so that we will include the voices of minorities, especially in New Zealand. They have such a mechanism. I think in Taiwan, we also need to reflect these principles in our NPM. The National Police Agency's role is to implement the domesticalization of the international laws, and we will also play a role in writing the state report, and also the annual report. MP8 will factor in the recommendation come from the reviewed, and we will also convey the actual recommendation to the NHRC. Thank you. So it can be MPA or the Ministry of Interior. And last night, we also talked to Ministry of Health and Welfare and the Ministry of the Justice. It was small-scale virtual meetings. But in the future, we will also have some communication with and criminal investigation of the office. So we look forward to partnership in the future. Thank you very much. Thank questions raised by the participants who join us online. This is an ongoing endeavor, and we thank the three panelists for your presentation and your insight. I also invite all those who join us online for input. Thank you. That concludes our first session. Thank you very much, distinguished moderator and discussants. The second session will start at 2 o'clock this afternoon. Make sure that you join us at 2 o'clock for the second session. Thank you.
是吗？
那麦克风你们都自己要拿起来，他们都有控制。您好，那麦克风的部分直接拿起来就可以使用，就 OK 了，谢谢。
有我的朋友通。
对，
哦，对对对对对。
这边是下一个操作。
这分别来看。我不用老婆，我可以了。
他们都不用太那个的嘛，反正我们是中翻英嘛。老师，
你好，你好，你好。
好久好久不见了。操作2楼。这场自己经过，他们主要分委员，他们自己操作嘛。对。
以前的联合报嘛。
我的公司这个是中手。联合应该是委员你好。
6位。
后来当
都是美。
就说你的麦克风好重。
我们现场都到齐了，工作人员就位了。
要拿麦克风吗？哦，
他这麦克风真的很重哎。
麦克风哈，不，
要练取测。
监察院有分量的麦克风。
各位贵宾以及线上正在收看直播的朋友们，大家好，大家午安，欢迎回到酷刑防治国际运作及渔工人权专业论坛。我们现在马上要进行第二场的主题——渔工人权之权宜船仲介议题。那现在呢，我们就马上把时间交给我们现场的主持人，国家人权委员会委员王幼玲王委员。
I will give the floor to Member Wang Youling of the Control Yuan. I know President Chen is also online joining us. My name is Wang Youling. I'm the Commissioner of the NHRC. This is the first time for us to talk about these two very important topics, NPM and also fishermen's human rights. In the afternoon, we have 2 hours and a half to talk about fishermen's human rights in Taiwan. I'm the moderator for this session. The United States have included Taiwan's distant water fishery into the list of the forced laborers. That, of course, hurts Taiwan's human rights reputation. This is an imminent issue we need to address. And of course, this is also a very challenging issue because of the FOC, flag of convenience, the issue. Unless there's any human trafficking issues, Taiwan actually does not have the jurisdiction over these FOC ships. We have the 4 speakers representing Control Yuan, academic, and also the private sector. We have a total of 17 minutes. Each speaker can speak for 10 minutes, and then we will have 20 minutes for interaction. The first speaker is Ms. Wang Meiyu, members of Control Yuan, the 5th and the 6th Control Yuan. She has put in a lot of interest in this issue. She talked about the offshore and also domestic fishermen's human rights, especially FOC. Her topic is stop forced labor on the sea, cracking down on human trafficking. She will talk about a lot of the issues we need to address in Taiwan. The second speaker is the most respected Professor Xiaoxin Huang, also the consultant to NHRC. He will talk about the issues dealing with FOC, especially the brokerage system. The third speaker is Ms. Murphy Chen from Greenpeace. She will talk about the crisis of the foreign fishermen's human rights. The last speaker is Director General of the Fishery Bureau. He will talk about how Taiwan can provide better protection to foreign fishermen working on the deep water fishing vessels. Hopefully, we will have a lot of questions after their presentation. So let's have Commissioner Wang first. Thank you very much, Madam Moderator. Ladies and gentlemen, good afternoon. I will talk about how we can stop the forced labor on the sea. In Taiwan, we have the domestic fishermen and offshore fishermen. From this chart, you can see there are different regulators for brokers introducing the fishermen. And for the offshore, the foreign fishermen, the total number is 19,642. And for the workers introduced to work for Taiwanese vessel, the number is 11,343. I think the issue we need to deal with is FOC. There's Taiwanese ship owner, but the ship are registered in other countries. FOC receive a lot of criticism because the brokers are Taiwanese, the ship owners are the Taiwanese, but we do not know the exact number of these foreign fishermen. And also there have been many human trafficker or human trafficking issues. In 2015, we had an investigation report of the one vessel. This is for Fu Shiqun, the vessel. One fisherman died. You can see that the abusive working condition, the monthly wage is lower than $450, and including the bounds. Bound, that means the workers cannot run away. They have to stay on the job for at least 2 years. And also, the Control Yuan investigated this case. The settlement is 10,000. And arising from these cases, we can see that for these offshore fishermen, they are entitled to have better contractual terms with the employer, including insurance. And also that the contract signing process had to be recorded. We talked about the management of FOC vessels. The one regulator is Council of Agriculture. In 2019, Greenpeace accused these 5 fishing vessels of a lot of abuse and also mistreatment of the fishermen. And some of the workers are victims of human trafficking. And then some of the cases are in the process of being investigated by the prosecutors. If you look at Taiwan's fishery laws, Taiwan actually does not have any jurisdiction over these FOC, the vessels. And the Council of Agriculture, Fishery Bureau is also not the agency. The cases of human trafficking should be reported to. There shouldn't be any human trafficking on the FOC. If you look at the human trafficking report published last year by the United States, you can see that Taiwan is still facing some of the accusation, and based on the statistics of the fishery bureaus. As of the March 30th, 2020, you can see Taiwan has 241 FOC, the vessels. The government tried to tackle this issue aggressively by amending the related laws for those non-Taiwanese fishing vessels. Receiving a lot of criticism, Fishery Bureau had a standard operation procedure to deal with these cases. By end of February last year, this is the cases reported to the judicial authorities. We do not have jurisdiction over this FOC, but there must be something we can do. Well, according to the international covenant, the FOC, the vessel, that should be regulated by flag states. There are some cases we are accused as the transit countries or the post state or even market state. What we can do is to pursue international cooperation to crack down on human trafficking. Here you can see that in the 2020, we actually have the number of fishermen reduced by 19,000. Then some of the contracts are very unreasonable, including the low wages, and also some of the contractual terms are unfair to foreign fishermen. For the offshore fishermen, a lot of them are missing. Actually, more than 80% of these fishermen are missing. Some fishery operators introduce the foreign fishermen to Taiwan by themselves. And then we do have some survey and analysis on these cases. More operators have been punished by bad practice. And some of the fishermen are not documented. They are just like those workers on the ship. And we also have inspections for the labor inspection, including the inspection of the working condition for these fishermen. The control yuan interviewed the two workers virtually. One say that they worked 2 years and 3 months. They work 16 hours on average. The monthly wage is 300. And also, part of the wages have been withheld. He only received the income of the wages for 8 months. This chart is a list of these abusive working conditions. The government of Taiwan does not have jurisdiction over these offshore workers, but we receive a lot of criticism by foreign countries. As a result, the Ministry of the Labor is another agency we need to review. It seems that the Ministry of the Labor does not see the fact that some of the fishery workers have been working in the black market or are documented since the Fushicun vessel. In 2015 until 2020, you can see we have the basic labor regulations for these offshore fishermen. And the consensus is to domesticalization of the IAO Convention C1AA. One focus is on human trafficking. We need to have good records so that we can track whether or not any wrongdoing are committed, or that whether or not the workers are working under abusive working conditions. I have been working for Control Yuan for almost 7 years. I think I have to say thank you to the private sector for their help. And I'm very happy that NHRC is looking into this issue with the partnership of the government and the private sector. I think the foreign fishermen, including domestic and offshore workers, can have better working conditions in the future. Thank you.
Thank you very much for your informative presentation. I believe that due to interest of time, you were not able to dig into all the details, but still, thank you very much. Moving on, I would like to invite Professor Xinhuang Shao, consultant to National Human Rights Commission, to give his presentation on malpractices exposed in the FOC and the migrant fisher brokerage system. Ladies and gentlemen, dear participants here and online, thank you for giving me this opportunity. FOC and migrant fishers are an issue not attracting enough attention, especially on the issue of FOC. If the Control Yuan didn't ask me to speak on this issue of FOC, I wouldn't go on and research on it. As I believe that 80% of people in Taiwan have no idea what FOC is and why it is so problematic. What is FOC? Well, in fact, after 1950, FOC became a commercial practice or a political practice, or it is a practice that leads to so much malpractices. The second problematic issue is the brokerage system. In Taiwan, there are more than 700,000 migrant workers. Migrant workers are also dispatch workers. On land or offshore, there are workers who serve as domestic helpers or caretakers or fishers. But fishers are very different. We cannot go and inspect the labor condition of the fishers, and therefore their situation is more problematic. They may be victims of human rights violation or exploitation. So I would like to thank Control Yuan for giving me this opportunity to research on FOC, flag of convenience. The Chinese translation of it is the ship of convenience. It appears to be neutral, but in fact, it is not a neutral term at all. It is convenience, I think, only for the business operators, but not for the fishers. There are also other translations, for example, ships of convenience. Again, it is only convenient for ship owners or business operators, but not for the fishers. So it is a unique situation, but it's a reality. an issue that so far cannot be solved. And labor issues are very common on this kind of ships. So ILO is working towards eliminating this kind of FOC practice. So how many FOC ships are there in Taiwan? According to Ms. Wang's presentation, I think we learned a lot about it. And currently there are around 241 FOC ships. And Taiwan has quite a few of them. Why is that? Because of the convenience for the commercial world or for the political realm? I think we need to understand FOC from historical, economical, and political perspectives. So among the 241 FOC ships, most of them are registered at Panama. There are 73 and 71 from Vanuatu, and 36 registered at Sasir. And there are also 6 and 7 and 4 and 10 from USA, Matar, or other smaller countries. So this number is already less compared to 2018. Is it because the government has imposed stricter policies, or is it because ship owners don't find it profitable enough for them to operate? Or is it possible that they receive complaints? But all in all, I think FOC is problematic because it is not very clear as to who should be more responsible, the ship owners or the registration country or the transit country, and so on. So if the laborers are exploited, if there is illegal fishing, which country should be responsible? And to inspect the labor condition of the fishers on these ships is extremely difficult because the scope of responsibilities are not clear. So this makes the situation much more challenging. So FOC should be able to manage in a better way. But let me talk about FOC first. So the biggest problem is there's a scope of responsibility or who should be responsible. But since Greenpeace, labor associations, or the governments have all read relevant reports and understand that this is a really weird situation. It exists. Everyone thinks this is a very challenging problem. But why is this our reality? So it's unclear responsibilities, as I said earlier. So should the ship owners be responsible? But if the ship owner is not Chinese, what happened? There was a ship when a Malaysian Chinese was the owner, but Taiwanese people invest on this ship, and that ship was hijacked on the sea. So no parties thought they had the ability or the responsibility to deal with that situation. Of course, we understand that these ships are not allowed to engage in human trafficking. But of course, these kind of ships wouldn't say that they are involved in human trafficking, but we have to look at the practice. If they have act indicates that they are involved in this kind of cases, they are not, or they shouldn't be allowed to conduct their business. I also talked about brokers earlier. Many scholars in Taiwan study the brokerage system. When it comes to brokerage, and I think exploitation is a really big problem. And in Taiwan, there are laws regulating what fee should be paid by the migrant workers to the brokerage. For example, introduction fee. is equal to 1 month's salary. That's about $300 to $500. And the migrant workers have to pay the brokerage $2,080. There's also the deposit fee, which is not part of the laws. When we look at other migrant workers who may not be fishers, they complain about the brokerage system quite often. So the situation must be even worse among fishers. I think the way of paying the salary to migrant fishers is a problem, because currently the ship owner will pay the Taiwanese brokers. The Taiwanese brokers then pay the overseas brokers in Vietnam or Indonesia. Then the foreign brokers pay the migrant workers. It's possible that the foreign brokers don't pay the migrant fishers properly. Another issue is migrant workers who run away. In Taiwan, there are about 50,000 migrant workers who are not documented. We don't know where they are. It's probably more difficult for fishers because fishers have nowhere to run to unless they are on the land. So brokerage system is problematic, but it's more and more serious right now. Especially there is some difference between migrant fishers who are hired offshore and onshore. But I cannot really say that which issue is more serious, but they are all worth further studying. Local governments have the power to inspect the payment system and whether or not the human rights of foreign fishers are violated. But it's really difficult to conduct effective inspection. If the brokers violated laws in paying the migrant fishers, they have to face a fine of 10 times or 20 times of that salary amount. But it's really difficult to spot these kind of cases. I think when we discuss brokerage system for migrant fishers, it is necessary to conduct a comprehensive overview of the labor condition and payment system and brokerage system for all the migrant workers, including those who work in factories and in homes, including migrant workers who are hired offshore or onshore. So we need to put migrant workers into different categories, but conduct a comprehensive study on brokerage systems for different kinds of migrant workers. Among all the issues, I think the brokerage system for FOC is the most challenging. Is it different from the brokerage system for non-FOC ships? I think it's even more difficult to follow up who should bear the responsibility for FOC. Should we go after the registration country or the ship owners or the fund provider or the brokers? And there are two kinds of brokers, Taiwanese broker and foreign brokers. So some foreign brokers have the same practice as Taiwanese brokers, but some don't. So again, it deserves further research. I think I cover most of my slides right now. So moving on. My recommendation for FOC is that, first of all, we need the government to have a very clear attitude. Should we phase out FOC practice? Or should we allow it because it's profitable? Because I read some public and private reports. It seems that the Council of Agriculture tends to believe that FOC is not necessary. But I think there's another fishery association thinks that it's necessary to have FOC, and the chair of that association has a really good relationship with people at Council of Agriculture. So I think Control Yuan can conduct more research on this issue. So I read the 2 reports published by Control Yuan, which I think are very informative because it helps me understand that this is a big social issue. And the Control Yuan need to continue to supervise it, and so is the executive branch of the government. Thank you.
Thank you for pointing out for whom, and also whether or not we should abandon the system of FOC. Next, let me thank the next speaker from Greenpeace, Ms. Murphy Chen. She will talk about the human rights crisis on FOC. I think this is the practical experience sharing. A lot of stories about the sweaty labor. Madam Moderator, ladies and gentlemen, good afternoon. My name is Murphy Chen. Thank you very much for the invitation of NHRC. I will talk about the human rights crisis on FOC. The previous panelists have talked about what the flag of convenience is. The ship owners can choose to register the ship in other countries. In 2010, we published a report on FOC in Taiwan, including the reasons for the ship owners to do so. The first reason is the low registration fee and also tax benefits. And the second reason is to access the cheap labor. And thirdly, the flag state usually does not have any resources to govern or regulate FOC. If you look at these slides, these are the countries punished by EU by issuing yellow cards and red cards. And this is the numbers from the Fishery Bureau. In Taiwan, we have 243 FOC vessels. You can see that around 67% of these vessels have received yellow card or red card from the EU over the past 7 years. That means these flag states really do not have resources to regulate these fishing vessels. The top country of registry is Panama. In 2019 to 2020, 2021, 3 times Panama received a yellow card warning from the EU, followed by the Vanuatu. Let me also talk about the relations between FOC and forced labor. I will give an example of Taiwan's FOC Dawang. The fishing vessel was registered in Vanuatu. The operator is Taiwanese. We received a complaint from the fishers in 2019. Actually, in 2019, we also received complaint from another FOC, the vessel. According to the most recent information, the Dawang received another complaint. These are the contents of the complaint. It actually includes 6 out of the 11 criteria to constitute forced labor, including abusive working conditions and also physical violence, withholding wages, and work overtime. the testimonials from the fishers include the following. The Indonesian and also Filipino workers receive the different wages, and when the catch is big, they have to work very hard without any rest time. And one young Indonesian fisher died after being physically abused by Taiwanese officer in 2019. And in 2012, they came back to Taiwan, and the workers filed complaint to the 7 NGOs. So the Greenpeace also held a press conference on these issues, and also the United States, the Customs and the Border Protection issued the withheld release order, WRO, to Taiwan. And this year, Greenpeace published the most recent report that Taiwan was on the list of receiving complaints from the workers. Some of the video clips for the fishers working on Taiwan, the FOC vessel. Watch the video clips.
Hindi daw ako magsusumbong kahit anong
The
government,
brokers
Taiwan
asked me now to
government.
report
Kung
to the
magsusumbong daw ako,
Taiwan government. They say
ipapahol daw ako ng police. Yun ang sabi nila
I
sa akin.
report the case to the
Pagdating ko,
government,
ma'am,
I will be
sa
called by the
immigration
police.
Kosyong, doon ko nakita yung ano ma'am, yung
When
pangalan
I
ko na
went to
nag-jump ship
the
daw
National
ako.
Immigration Bureau, I
Ako
saw
yung
my name.
nakasulat doon. Ako yung unang nag-jump ship.
They
Pero
accused me
ang
of
nakasulat
running
doon, ma'am,
away.
yung ano papel na yun. Ako yung number
I
one na nakalagay doon.
was the
Tapos
first
pitong
fisher
Indonesia. May
running away,
pitong Indonesia daw na nag-jump ship.
according to
Pero
them.
pangwalo daw
And
ako.
also,
Pero ako yung
7 other
pinaka-number one na
Indonesian
nakasulat doon.
fishers also ran
Sinabi
away
dapat bumaba ako sa
from
barko.
April
Sabi ko,
20th to May
Ba't
4th.
ako bumaba? Ba't nag-jump ship ako? Sabi ko sa kanya.
I stayed in a place
Nakalagay doon kasi ma'am,
arranged
May 1.
by
Paano
the
mag-jump ship
broker.
ako? Isa hanggang
How
April
could I
20
run
up
away
to May 4.
from
Nandun lang ako sa
the
accommodation na
ship?
yun, ma'am. Yung tinago nila ako doon. Ano ba yung feeling mo?
I was
sabi ko, sir,
really tired, exhausted. I had headache all the time.
Gusto kong mapacheck up sa hospital at makabili ako.
I wanted to see a doctor,
Yung agent ko, sabi
get
ko,
some medicine to
hindi
see
ako
whether
binibilhan ng ano ko.
my condition will turn better, but the brokers did not help me. Buy medicines. I will wait until the day 14. Still no medicine. Okay, let's stop here. Thank you. From the video clip, you can see that Taiwanese brokers also violated the human right by depriving the liberty of the fishers. They claimed that the fishers ran away from the vessel. Why we see the loopholes often on FOC and also the crisis of human rights and the IOO, the fishing in the Taiwan. We do have this regulation. This is the FOC operation and management rules, but it is very difficult to govern the FOC under these law. The investment process is very complicated. Anything happened on the vessel or forced labor, a lot of time you cannot trace back to find the real fishery operators because of lack of transparency. any disputes or any cases on FOC, the government will say that this is a foreign vessel, that we do not have the jurisdiction. If it involves human trafficking, the government will say that they do not have any investigating power. The fishers on the vessel usually do not know that what country they are working for. That also exposes a lot of vulnerabilities in terms of human trafficking. Even if some of the laws have been amended, especially Article 2 and Article 6, you can see like Dawang and Jinchuan, these the violators are still on the list approved by the regulator. There are the two legislation, the labor standards law for onshore fishers, and also another legislation to govern the offshore, that's the distant water fishery workers. More cases need a non-harm number 3 vessel. This is the kidnapping the cases by pirates that was case heatedly debated on the media, as Professor Xiao just told us, that the ship owners was Malaysian Chinese. But this vessel had never included in the FOC list compiled by the Fishery Bureau. Another FOC, this is the tuna gold 61 registered in Vanuatu. The Indonesian workers killed the Chinese captain, and the forced labor was also involved with this FOC. Internationally, we do see that there's some appeals for FOC. In here, we see the report issued by Ministry Department of Labor of the United States, and they included Taiwan's distant or water fishing into the list of the products produced by child labor and forced labor, and also the human trafficking report published by the Department of State, U.S., also mentioned Taiwan. In 2019, ILO also had a similar mention. In May this year, the Control Yuan published the investigation report on Taiwan's distant water fishery. There's some mention that we need to have a more complete administrative and judicial jurisdiction over the FOC to change the situation on Taiwanese FOC. Greenpeace have partnered with other NGOs. Actually, 7 NGOs are working together to call for a stop to the operation of the FOC. Before that happens, we also like to urge the Taiwanese government to designate Ministry of Labor as the regulator for FOC, and also for the management rules on FOC, we believe that they need to include the basic working condition, including the basic wages and also the cap on working hours. In Taiwan, we are in the process of to bring the spirit of the ILO C118 convention into our domestic law. We hope that we can get that done soon. Thank you.
Thank you very much, Ms. Chen, for explaining why IUU and C188 saw that FOC is a big loophole. Now, we in Taiwan seems to face the lacking of regulations or laws to regulate FOC. Next, I want to invite Qi Chang, Director General of Fisheries Agency from Council of Agriculture. I think you are probably now under a lot of pressure because you represent the government. And Mr. Chan will talk about what measures are taken by the Taiwanese government to improve distant waters fisheries. Ms. Moderator, dear panelists, ladies and gentlemen, good afternoon. Thank you for giving me this opportunity to talk about FOC and the brokerage system. And I am really deeply touched after hearing previous presentations. It's a very complicated industry, and not many people really understand what's going on within the industry. And in my presentation today, I want to talk about the general situation faced by migrant workers, and I will also talk about FOC. Now, there are about 1,100 distant water fishing boats which hire 21,000 migrant workers, among which 30% are from the Philippines, 60% from Indonesia, and the rest are from Vietnam and other countries. Some are hired through brokers. Some are hired directly by the operators. Now, the international community pays attention to several issues, including whether there is debt bondage and whether or not the payment is paid in full, what's the labor condition, what's the condition for daily life, and is there sufficient management of the brokers? Is there lacking of the management of FOC? And whether or not there are enough international cooperation and training sessions. So here is a little background of FOC. So FOC are the ships which allowed investment in countries which have really loose regulations. Because fishing industries or fishing organizations in different countries have really strict quota for ships that are registered in various countries. So if a ship catch a certain amount of fish, and if there's a 10% or 20% over the quota, the boats will be fined. There are about 240 FOC. And Japan used to send their older ships to other countries, which become FOC. And Taiwanese ships, which are newly built, may be used as FOC as well to places with less regulations. And I think Japan bought some ships back, and the new FOC ships produced in Taiwan, or some of them, are re-registered in Taiwan. So in short, FOC means that ships which are invested by Taiwanese people, but they're registered in different countries. So of course, Taiwanese people have the right to make investment overseas, but their practice have to be in line with international practices. So this is the background of FOC. But does Taiwan have the largest number of FOC? We don't have that number, but as far as I understand, many countries own FOC. And FOC do not always go to countries with less regulation. I think Professor Liao mentioned that there are FOC ships from USA or Japan. But the point is IUU and human rights. Currently, the Council of Agriculture allows Taiwanese people to invest elsewhere. So there are about 247 ships like that. So if the investment is larger than 50% of the value of the ship, then it has to be regulated by Taiwanese laws. It also needs to follow the regulations in the transit countries, and it has to report its business to Council of Agriculture. So people say that maybe we should just remove the license of FOC. But I think that's not the solution, because we simply stopped FOC from registering. They still exist, but they just don't come to Taiwan. So I think to solve the issues around FOC, Taiwan is not the only player, because in the registration countries, the FOC has to report their taxes and their revenue and so on. So I think we need to solve this issue instead of eliminating the registration, which doesn't really address the problem. Currently, I think instead of removing the practice of FOC, we in fact need to conduct better management. A responsible government needs to address this issue head-on and make the process more transparent. And there are fines here. You can see that it's really expensive. And the fine is between 2 million to 30 million NT dollars. And in some cases, violators need to serve sentence. So these are the fine and other penal punishments. If we simply eliminate the practice of FOC or remove these laws and regulations, that will not solve the problem. I think in the future, we need to do more. For example, we need to have joint ports inspection mechanism. Council of Agriculture and other government departments need to work together. The second aspect of improvement is on investment regulation. Everything needs to be done according to law, including international laws and regulations, and we want to comply with ILO standards. And the registration country should take the responsibility as well. So Control Yuan also gave us some suggestions which we will try to adopt. Now, on brokerage system, and in fact, the fishing industry in Taiwan relies a lot on migrant fishers. So some individual brokers will help find the migrant fishers. They know how to contact the family members of the fishers. Some local brokers need to pay salary to migrant fishers first. And currently, there are some qualification requirements on who can operate a brokers. And brokers have to pay deposit first as a guarantee. And supervision and management needs to be strengthened, of course. So currently, we are asking help from NGOs to come up with a better assessment mechanism for the brokers. Inspection and complaints. Another aspect, some NGOs accompany government officials to inspect the ships, so we would include their recommendations. issues around FOC or brokers are really common, and they are structural problems. And we need to respond to these complaints in many ways. For example, direct payment to migrant fishers. Sometimes the ship owners pay the amount in full to the Taiwanese brokers and then to the foreign brokers, but the foreign brokers do not pay in full to the migrant fishers because these foreign brokers say that these migrant fishers ask for a loan before they started working. But I think we need to separate these two things. And we also need to have better inspection capacity because some of the issues were only exposed 2 years or 3 years after it happened. So we need to increase our inspection capacity, and we need to work with country of origin so that the workers do not have to go through brokers in order to get a job. And that we want to eliminate debt bondage. So there are some laws or regulations on these parts. And we have 7 strategies to address human rights issues in fisheries. Some of them are directly related to FOC and the brokerage system. I think we need a structural policy to address structural problems, and problems about legal loophole needs to be addressed with more comprehensive laws and regulations. And we have a zero tolerance policy towards human rights violation, but we need to work with the registration countries. So it is really important to work with the registration country to address FOC issues. Some ships do not have the nationality or registration. For example, the ship we heard about was registered in Oman, but there's a Taiwanese person on it. So if there's some issue on this ship, should Taiwanese government have the jurisdiction? I think this is worth more discussions. Thank you very much.
I think we have used up the time allocated for this session. We expected that Director General will respond to the question raised by the other panelists. He just said that, well, the real solution is not to remove all the FOC. Monitoring, supervision, and transparency may be the way to go. But still, we really need to review the situation. Well, you talked about the supervision, transparency. Those 2 words sounds very empty. And Greenpeace has followed the issue for a long time. So far, we haven't seen any concrete measures taken by the regulator. The questions on the brokerage, you talked about the inspection capacity and also some other likely solution. I think it takes time to make these measures more effective. It is a challenging issue. We talked about Taiwan's distant water fishery has been included into the list of the goods produced by child labor or forced labor, and they will review the list biannually. So we do feel there's some pressure, and even the whole food, the organic food, chain store also expressed their concern about the practice of the FOC. We have some questions. There's a question, any cases where the some fishers were forced to stay on the vessels. And also, we talked about the ILO, the C118 is domesticalization. Any schedule for such a legislative effort? And then also for the foreign fishers' wages, if you convert that into New Taiwan dollars, is really, really low. Is this legal to pay such a low wages? Greenpeace, maybe you can answer the first question based on your experiences. Any de facto prisoners were forced to stay on the vessels. The first question, what we know is that the migrant worker usually signed a contract for 2 years. Under the contract, if you want to leave, when the 2 years has not expired, then your deposit will be withheld. You also need to pay the high penalty, and you need to pay your own the travel expenses, including airfare back to your country, and you need to talk to the brokers. Last year, I talked about Da Wang and also Jinchun of the 12. Some migrant workers filed complaint because they really experience abusive working environments. So they talked to our alliance. So we talked to the NIA and also fishery agency. There was forced labor involved, including a lot of working conditions, the food, and also the living conditions. How can they leave these vessels? It's very difficult. They usually just talk to NGOs or the alliance I just mentioned. The Control Yuan held the virtual interviews of the victims. They say that since it is a 2-year contract, I say that if you run away, want to leave before 2 years, then their deposit will be withheld by the owner. So the 2 years they will stay on the vessel, and their food will be provided by the supply of the vessel. So when you say forced to stay, or is it the prison at sea? Since they are on the sea for 2 years, or what you can imagine the abusive working conditions. Director General, thank you. 3 parts. Well, this is a very different working environment. The working environment is at sea. So you can, that's why I say that we need to work closely with the source countries. And the ILO Convention C118, Ministry of Labor is the regulator working on nationalizing the ILO C188 into our domestic law, including the rest time and also the working conditions at sea. this is something we will do, but we actually have the new governance rules moving in this direction already. And the wage, maybe we need to compare this with the international standard. You may think it is very low, but the NGOs probably can do a survey. Some countries actually offer much lower wages to these migrant fishers. But in the future, now the issue is the disparity between the fishers working onshore and offshore. But at least this is what the current regulation has provided. The C-188 Convention. In the inspection report by Control Yuan, we also include this convention several times. We will follow up on any new development. Commissioner Wang also explained the different regulations and applicable laws for onshore and offshore workers at sea. So you think that, well, $450 is very low. I think in Spain that's $500 but they also they give bonuses or performance bonuses to the fishers. Professor one more, a couple of days ago, what expressed is wishes that the NRC will deliver a complete report on migrant workers. The question is, how many FOC vessels have been delicensed or their operating permits have been removed based on the governing the laws, and for the Taiwan vessel, they still can return to Taiwan? Or can we send the officials from the fishery agency to inspect their ships? Well, the first question, a small number, any violation will lead to our measures to rescind their permit, and the investigation of the Taiwan has been at the district prosecutor's office, and we are still waiting for the final result. And thirdly, how about the post-date laws and regulations, post-date agreement? We actually do not have that, but we will refer the case to judicial authorities. So starting from last year, Taiwan returned to Taiwan, the Coast Guard and also the judicial agency began the investigation process for SUS. We hope that we will have the more clear idea about the governing laws. Some organizations are helping us to understand the case, as long as it involves any individuals the right or need to provide any basic protection. The fourth question, I have the same question. Why there's forced labor or the labor exploitation? They usually will go to NGO first. I also have the same question. Maybe Commissioner Wang, you would like to add a little bit to respond to this question? As a matter of fact, the government usually say that we do not have jurisdiction. The administrative police does not have a relevant legal basis to enforce its power. For example, to impose a heavy fine on the human trafficking cases. What I'd like to stress is those unreported or those undiscovered violations. Since these ships are not registered, there's no way for you to know whether or not there are violations on these fishing vessels. Professor Shaw, you have final word, the last minute. Let me say that, well, if this is something we have no jurisdiction, you have no way to govern, then, well, FOC should not exist. This is the voice and the mindset of the private sector. Just like the new southbound the policy, we have Indonesia and also the Philippines. These two are the new southbound countries. We also have so many migrant workers from the new southbound countries. So it's very important to take good care of the human rights of these people, migrant workers from Southeast Asia. This is why I'm here, because this is a very important issue. I have a lot of interest in it. Thank you. Thank you very much. That concludes this session. This is the issue for Fishery Bureau, as well as other agency of the executive yuan. Thank you. Thank you very much. We will take a break, and the third session will start from 3:20. Thank you.
Ladies and gentlemen, welcome back to the Forum on International Practices of OPCAT-NPM and Human Rights of Fishermen. In the third session, we want to talk about fishermen's rights, especially working conditions, healthcare, and social security. The moderator is Commissioner Ji Hui-rong from National Human Rights Commission. Ladies and gentlemen, good afternoon. It is my honor to serve as the third moderator. In the previous session, we have had some discussions on FOC and brokerage system. I believe that we all feel that much more improvement is needed for fishermen's human rights. So moving on, we are going to focus on working conditions, healthcare, and social security, as well as protection. I would like to introduce to you our panelists. First, Mr. Cong Yi-cai, member of Control Yuan, and John C.F. Wei, consultant of National Human Rights Commission. Our third panelist is from an NGO, Secretary General of Taiwan Association for Human Rights, Mr. Shi Yixiang, and a representative from the government, Director General of Workforce Development Agency from Ministry of Labor, Mr. Shi Chen-yi. Thank you very much for being here. And there are two ways of employment of migrant fishers. I think we heard about this in previous session. There is local employment, and there is also overseas employment. And fishermen who work under these two methods of employment have different working conditions, healthcare, and social security. And overseas employment means that whether they work on Taiwanese ships of FOC, they are not protected by the labor standards in Taiwan. There are about 19,000 of these due to the pandemic. Domestic employment means that these migrant fishers are protected by the labor standards, but they only 50% of them have labor insurance. And in 2020, there were about 10,000 like that. So what we're concerned is migrant fishers who work on distant waters boats, because they work under very challenging conditions. Their minimum wage may be even less than $450. They don't have comfortable resting area. They don't have clean drinking water, bad medical care, no space for proper shower, and long hours of working. They face really challenging working conditions, and since the local laws or regulations do not apply, they are not protected properly when it comes to their labor conditions and health care. So they work overtime, which is very common. Some overseas migrant fishers are seriously exploited, and some are even involved in TIP cases. Well, on June 20th, 2016, Taiwan started to have our distant waters regulations. We amended Fishing Act and so on. And the laws on regulating non-Taiwanese fishers was also promulgated. And therefore protection or a minimum wage should already be protected, but are these laws really applied? I think that's what we wanted to discuss during this session. First, I would like to invite member of Control Yuan, Mr. Cai Quan-yi, to give us his talk on forced labor at sea.
Thank you very much, Madam Moderator, friends. The topic I would like to talk about is a very important issue for any free democracy with the rule of law, that we need to provide human right protection to everybody. In 2015, the European Union issued a yellow card warning. And the yellow card was lifted on June 27, 2019. But later, we received another yellow card warning by the EU. In the 2020, the United States included Taiwan into the list of the goods produced by child labor or forced labor. And here, you see that the whole food market, the senior vice president wrote to the President Tsai their concern. This means that the CSR, this company yesterday, the Greenpeace, also issued some warnings on the forced labor at sea. International trend includes these C118. This is the issue receiving more and more international attention. The content of the C118 will be nationalized. For example, this morning we talked about torture, and last session we talked about FOC. This is the last session of this forum. We need to discuss whether or not we make it a reality to have the Taiwan legislation reflecting the content of the C118 Convention of the ILO. This is another international covenant adopted by the United Nations in 1990. We do not have plans to domesticalize these international conventions. What I'd like to mention is Article 47. It covers the migrant workers hired in Taiwan or hired in other countries. The treatment should meet some basic requirements, including the wage level of the $450 US. To earn the $450, these migrant fishers were working in very abusive working conditions. Sometimes their wages were withheld. They worked very hard on the sea for 2 to 3 years, but they did not receive the payment. Well, Taiwan is a major country in distant water fishery sector. Out of CSR and also empathy that we should treat these migrant fishers well. For those hired in Taiwan, the increase is not that much, but you can see the numbers of the offshore fishermen is increasing very fast from 11,000 to closer to 20,000. That's why we need to ensure that they also enjoy the basic human rights. As what has been discussed in the previous session, the migrant fish are mainly from the Vietnam, Indonesia, and other new southbound countries in Southeast Asia. You can see some of the complaints the exploitation of the laborers. And one of the cases happened when the Nanfang Out Great Bridge collapsed in 2019. And I talked about the undue attention from the United States on human trafficking. In 2015, July and August, Fushichin, a fishing vessel involved in abuse of the Indonesia fishers, and one death case. And we discovered that they actually signed 2 contracts. One legal contract that's for outsiders. The other one is the actual contract for internal use. We interviewed these fishers. A lot of the sad stories. They worked in a very bad environment. Sometimes forced labor at sea is so common. The minimum requirements to get paid on time, which is not always happening. So many accusations and complaints involving this Ford fishing vessel yesterday. The Southeast Asia Office of Greenpeace told us that actually there are the 5 Taiwanese vessels. They investigated 62 the fishing vessels from 2018 to 2019. 59 carried Taiwanese flag, 3 the FOC, and they found a lot of the complaints. Greenpeace gave us a lot of warnings, alerted us that there are actually 5 vessels. The workers on the 2 vessels received their payment, but the other workers on the remaining 3 vessels are still to receive the payment. See, this is the NGOs from 34 countries, also the alerted Taiwan. Taiwan's government, of course, has taken some measures from 2016, 2019, mainly on the working hours and also the wage level. They raised to $450. The question from the last session is whether the wage is so low. But we had the panelists respond by saying that some countries pay the fishers even lower. So that the requirement is not lower than $450 monthly. Of course, the ship owners, the operators can pay higher wage. And also the labor exploitation should not happen in 2017. Some measures are also taken. We have the $1 million insurance policy for fishermen. Whether or not $1 million New Taiwan dollars is sufficient is another question. The control yuan should supervise what the government has taken to improve their practice, especially that the domesticalization of the ILOC 188. the human trafficking, this is a multi-agency effort. It also takes international cooperation to crack down on the human trafficking. The message from the United States is that the judicial authority should gain more knowledge about human trafficking cases. Article 2 of the Human Trafficking the Prevention Act, this definition for human trafficking, labor exploitation, and also abusive treatment, and also the Article 31. It is about the punishment of the 6 months prison term for sexual exploitation. And every year, you can see we have around 30 cases of labor exploitation, and 80% of these cases are actually handled not to the satisfaction. 80% of them, the perpetrator did not receive the right punishment. So in the interest of time, let me just stop here. You can read my paper and the PowerPoint. Thank you.
Thank you very much, Mr. Tai. The report which was mentioned earlier was published by the Control Yuan. As of now, the Control Yuan really attach a great importance to ending forced labor. So currently, NHRC is aiming at publishing another special report to follow up with this issue. Next, I would like to invite John C.F. Wei to speak on C1AA from ILO. So that's a convention on fishery work. And he will talk about the legal aspect of protecting foreign fishers. Can you all hear me? Ms. Moderator, ladies and gentlemen, good afternoon. I am an attorney in the field of Labor Act. I've been in the field for 30 years, and I teach at Judges Academy, and I also represent Taiwan to attend many international conferences on Labor Act. But foreign fishers is not my special topic, because for scholars in the Labor Act or standards, this is not the most researched topic. There are not a lot of migrant fishers compared to the laborers in other fields. But about 2 years ago, people asked me about foreign fishers. So that's when I started to read some research papers in Taiwan on this topic, but there aren't many, and there aren't many court judgment on this issue. So what I want to stress here is, well, I'm going to skip some important key points which were already mentioned, but if you go to page 129, you'll be able to see that the Ship Crews Act only applies to people who work on commercial boats. That's kind of odd. When it comes to fisheries, there are distant water fisheries, offshore and coastal fisheries, and aquaculture. We ranked number 2 worldwide when it comes to distant water fisheries, and the top one is mainland China. I think Norway is also one of the big distant water fisheries countries. It has the most advanced regulations in this field. I think we can learn a lot from their practice. So migrant fishers have to face really bad living environments. Their wages is deducted, and they are forced into labor too. There are 3 important fisheries acts which started to be applied since 2017, and the Council of Agriculture states that there is a guide for the working hours for the fishers, and the working hours, the rest that should be provided to the fishers. And some NGOs I'm not satisfied with this article, but I think this is a good article because offshore work is different from onshore work, because when the crew members are on the ship, they work and live on the ship. So the conditions are very different. And I will talk about some verdicts later. And Article 26 of the Distant Water Act also provide some guidance. Other articles talk about health care, employment, placement, and so on. And migrant fishers are protected by our Labor Act if they are hired domestically, but such standard doesn't apply to overseas employment. And the wage should not be less than $450 US. Because the ILO regulates that the minimum wage should be $650 US, but for Indonesian laborers, their common wage is $300 US. So Taiwan regulates this minimum wage to be $450 US. I did a lot of research. I actually went to review several court verdicts. There weren't many, and most of the cases are in Yilan, Keelung, or Kaohsiung. The one in Kaohsiung is not really significant, so I want to cite 2 cases from Yilan and one from Keelung. Now first, overseas employment. So let's say A is a Philippine fisherman and B is a Taiwanese boat owner. And this contract applies Taiwanese Labor Act. That's interesting in the verdict, because this is overseas employment. Because I saw some cases where only domestic hires can apply Labor Standard Act. But there is a problem in the judge, because this judge is not very familiar with fisher who works on high seas. So this judge doesn't really specifically talk about the working hours or rest time to be offered to the fishers. And another verdict is from Yilan District Courts. So again, the Taiwanese Labor Act was applied. But the problem in this case is that I think both the NGOs and the government in Taiwan see that the local contract established in Philippines was a good one. But after the migrant came to Taiwan, he was asked to sign another contract because the litigation fee in the original contract should be borne by the owner. But he had to sign a waiver after coming to Taiwan. So I think NGOs and governments need to tell these foreign workers that if you signed the contract in your country of origin already and you're asked to sign another contract in Taiwan, please ask some others to review the contract for you. Because if you sign a waiver in Taiwan, then your rights may be waived too. And another very common issue is working hours, because if you're to catch squids, you have to work during the night. And the verdict in Keelung didn't touch upon working hours. So I see good things and bad things in the verdict. And C-188 became effective in November 2017. And UK, South Africa, and so on. Well, altogether, 18 countries signed C-188. Sometimes we think Japan has really good legal protection, but not so much in recent years, especially not for the fishers working on Japanese boats. Right now, C-188 is not fully domesticated, but there are administrative orders and regulations that have been amended. I think we need to acknowledge that onshore and offshore working situations are really different, and we also need to encourage the Fishers and Fishers Association to sign contracts where the Taiwanese Labor Act can apply. We can also refer to directives from EU, in which states that employers and fishers are social partners. So if these parties sign a contract that is regulated by Taiwanese Labor Act, I think this is a better practice. And according to my experience with the Labor Act in Taiwan, in Taiwan, we had a new labor law became effective last year. So mediation can really help in many of labor disputes. I think many cases can be resolved if different parties of a contract choose mediation. So these are my 2 cents. Thank you very much.
Thank you very much, Mr. Wei. Mr. Wei is also the consultant to NHRC from the actual cases. You can see some of the principles and the rules. It is very important for us to materialize the C-188 convention. Now, next, I'm going to invite Mr. Shi Xiang from the private sector, the General Secretary or Secretary General of the Taiwan Association for Human Rights. They welcome Mr. Shi. Thank you very much, Madam Chair, my fellow panelists and friends. Now, my name is Shi Xiang. I'm the Secretary General of Taiwan Association of Human Rights. I will talk about the chaotic policy on fishermen. You can scan the QR code to access my full paper. I'd like to thank members Wang Youyue, Wang Youling, and Ji Huirong for their efforts. I will cover the 6th report on different fishing vessels. I will also mention the alert from the United States to put Taiwan's distant water fishery in the list of products produced by child labor and forced labor. Let me go to my conclusion first. The Fishery Bureau still have not come up with the effective measures to resolve the abusive treatment of the foreign fishers. In 2009, Taiwan passed the Implementation Act for the 2 international human rights covenants, ICCPR, ICE, SCR. But these foreign migrant workers haven't benefited from such development. A lot of NGOs are urging the government to abolish those policies to allow the operator to hire migrant workers offshore. We need to adopt the same model to enact Taiwan's domestic law to reflect the spirit and content of the C188 Convention, so that the Taiwan government can really establish a supervision mechanism for cases like Fushi fishing vessels. And also the line of responsibility and accountability will be clearer. Let me start from Fushi on number 11. I call this ship a hell ship. We actually visited Indonesia to interview these migrant workers from Indonesia. Their testimonials reflect the violation of many IAO standards. When the ship was held, fishery agency that knew that, but did not disclose the fact. Well, fishery agency actually denied that had happened. Later, the agency went to the Indonesia to inspect the ship. In 2019, the EU red card was rescinded. There was something to celebrate. But in 2020, during the Lunar New Year, EU sent a delegation to Taiwan to inspect the ship. The comment is that the law enforcement density has become lower. The EU government officials alerted Taiwan if such situation was not improved, it was likely Taiwan would receive another yellow card warning. The United States also gave us a warning by including Taiwan's distant water fishery into the list of products produced by the child labor or the forced labor. You see, the Council of Agriculture, the minister said that next year, Taiwan worked very hard to be delisted. But there are still issues not addressed. From these news story, you can see that the COA, Council of Agriculture, will come up with some of the measures. But up to now, the policy on managing foreign fishers failed. We believe that these foreign fishers should also be protected by Labor Standards Act. The regulator is the Ministry of the Labor. In the 2018-2019 U.S. State Department's Human Trafficking report, there's also some mention about the human trafficking issue to Taiwan. On the Fusion 11, well, the recognition is that the fishermen should be governed by a Fishermen's Act. We always have the question of whether these vessels should be considered an extension of the Taiwan's the territories. Another aspect is the UN Law of the Sea, Article 92, 94. The ship carrying the national flag of Taiwan should be considered an extension of the Taiwan's territory. It is not just a vessel registered in other countries hiring the foreign the fishers. In 2013, there was one meeting deliberating on this issue. Very recently, the Minister without Portfolio Law also reviewed this issue. At that time, we discussed Chinese fishers and not Taiwanese fishers. I think it's about time for us to reconsider these issues. The executive yuan haven't come to any official position on this issue. The viewpoint of academics. Many academics believe that this should be a national policy. The Taiwan government need to decide whether or not this is in the national interest to include the foreign fishers into Labor Standards Act. My view is that while the United States gave us an alert, the EU also issued yellow cards. We really need to make changes so that we can be delisted from such a notorious list. And Taiwan can become a country that, which provide better working conditions and human rights protection to foreign fishers. The solutions to tackle these poor policies, I'd like to reflect to the two human rights covenants. If we follow the spirit and the content, then we know what we should do. And then another very important part of the solution is to enact domestic law to reflect the content and spirit of the C-188 Convention to provide protection to the migrant fishers. We should enact such a law as soon as possible. This is something we can do based on the experiences with Fushen 11 fishing vessel. When the case happened, Taiwan was not a state party to this convention, but South Africa was. South Africa could accuse Taiwan of violating this convention. This is a thorny issue for the fishery agency to tackle. The bigger problem is how we can establish effective governing or the supervision regulatory framework to tackle this issue. Thank you.
Thank you, Mr. Shi, representative from the NGO. He raised a few questions. For example, what's the role of Ministry of Labor, how to solve systematic problem, how we can implement ICCPR, ICCER, and C-188. So next, we want to invite Mr. Yang, Director General. Ms. Yang, Director General from Workforce Development Agency, Ministry of Labor. Hello, I'm from the Ministry of Labor. So Ms. Ji, Mr. Tsai, Mr. Wei, and Mr. Shi, dear participants of this forum. Good afternoon. I appreciate this opportunity to present our reviews on working conditions, medical care, and social security for migrant fishers. I have 7 main points here. My first point is on the background. Well, as a government official, I think laws and regulations are very important. And the fishing industry in Taiwan is very complicated. You know that there is coastal fishery, distant water fisheries, and so on. And there are 2 kinds of employment: domestic employment and overseas employment. For domestic employment, the competent authority is Ministry of Labor. So these migrant workers can look for jobs under the Employment Service Act and in Taiwan, and Labor Standard Act, Occupational Health Act, and Labor Insurance Act are all applied. And there are about 11,000 migrant fishers who are domestic hires. But when it comes to overseas hires, Council of Agriculture is the responsible authority. And there is a regulation on the authorization and management of overseas employment of foreign crew member, and Act to govern investment in the operation of foreign flag fishing vessels. So these are 2 regulations that apply to overseas hires. This table shows the number of migrant workers and migrant fishers. There are about 700,000 migrant workers in Taiwan, and 11,000 are migrant fishers, which accounts for 1.5% of all migrant fishers. Most of them from Indonesia, and then Vietnam, and then Philippines. So 72% of migrant fishers are from Indonesia. Next, I want to talk about the recruitment, employment, and life management for domestic hire. So it's within the scope of the Ministry of Labor. So there is management-related regulation for brokers. Currently, brokers must not receive or request service fee from migrant workers or migrant fishers more than 1,080 NT dollars. So in fact, in the first year, the service fee must not go over 1,800, the second year 1,700, and the third year 1,500 NT dollars. And overseas brokers are regulated under overseas regulations, and we advise the foreign brokers to charge the migrant workers no more than the workers' 1 month salary. So we propose this recommendation to foreign brokers, but we can only recommend. We're not able to ask them to follow it. For local brokers, there is an assessment mechanism. If they are assessed as C for 2 years in a row, then they will not be permitted to conduct their business anymore. Through bilateral meetings, we sign MOUs with countries of origin, and we ask these countries of origin to help the migrant workers, and ask these countries to punish their own brokers if they violate the laws. And migrant fishers are just like other migrant workers in Taiwan, which should go over process to get their work permit. And in 2016, in the Employment Service Act, originally, migrant workers needed to leave the country for at least 1 day after they had worked in Taiwan for 3 years. But that requirement was eliminated. They can continue to work in Taiwan without having to leave Taiwan, because if they had to leave Taiwan, go back to their own country, and then come back for their renewal contracts, they might be charged again by the foreign broker. And we have a regulation on migrant workers' vacation. The standard was created. So if the 3-year term contract expired, then there is a procedure for the employer to follow if they want to continue to hire the worker. As for the management of law, we devise daily life routine and care service criteria. So employers following these criteria have to check out the accommodation for the migrant workers. For example, there should be enough drinking water, sufficient space, because otherwise the employers may be subject to some fine. And any contract signed with the migrant workers have to be translated into their languages. Otherwise, this contract is not valid. And we also require employers to provide a salary form to the migrant worker in language they understand. And the next point is on working condition, because I'm talking about domestic hires. So, can I move on to my next slide? Okay. So again, this is on domestic hire. It doesn't matter whether they are Chinese or non-Taiwanese. They are protected by Labor Standard Act. As Professor Wei said, under Labor Standard Act, the employer can sign contract with fishers on their working time, rest time, and salary. So, control yuan and legislative yuan really care about the rights of migrant fishers. So we work with local governments, and we conducted 50 inspections. We also work with fisheries agency, because only fisheries agencies knows what ships are in, what ships are out. So local government inspectors will work with local fisheries agencies representative to conduct a joint inspection. We also perform targeted inspection. And for example, we needed to expect 60 operators according to the law. So I think the mindset of the employers really matters. What really matters is that the employers need to regard their workers as the people who work them and deserve their assistance or help. Laws and regulations won't be sufficient if the mindset of the employers does not change. Next slide, please. And since domestic hires are protected by Standard Labor Act, they have health insurance and labor insurance. So if any accident happened, they can be protected. So migrant fishers are protected with this kind of insurance. And in 2021 in April, a protection act for laborers in occupational hazard was promulgated. Any domestic hires will enjoy some subsidies and grants if they become disabled or if they encounter death as a result of occupational hazard. For migrant workers, we require the countries of origin to validate their contract. So the salary and the fees and so on should all be validated by the countries of origin. And the migrant workers, upon entering Taiwan, we show them some important laws and regulations, and also tell them that they can call 1955 hotline if they want to submit their complaints. We also tell them where the website is if they need information on the protection of their rights. They can also use Line, because we have a Line accounts which support 4 different languages, telling them where are the hotspots of COVID, and it is necessary to wear masks everywhere now. So we continue to create more channels to communicate with the migrant workers. If there are some employment disputes, we can provide shelters, and supported by the local government. We help pay for that shelter. And such complaints can also be submitted at airports. In my conclusion, Ministry of Labor want to protect migrant workers as much as possible, just as we want to protect the domestic Taiwanese workers. If they come to Taiwan, we want to protect their rights. But above all the policies or laws or regulations are not sufficient. The mindset and attitude of the employers really matter. If they want to treat these migrant workers fairly, it means that they have to respect their workers' rights. Thank you very much.
We have about 15 minutes for Q&A. Do we have questions? Can we show the questions? Online, we received some questions. The moderator can read the questions. I just read some of the documentations the official management of the migrant workers. So the question I have is why the actual condition, for example, the sanitary condition are very different from what has been published. So maybe the Director General Shi can answer the question later. The Fishery Association urge the ship owners to play a part in the training to the migrant workers. Other than the labor inspection, are there any administrative measures which can be taken? This is also for Director General. Do we have the third question? No. We have a third question. Migrant fishers is an issue that involving the responsibility of different agencies. For example, the COA, Council of Agriculture, and also the Fishery Agency is the regulators does not have the sufficient authorization to deal with these issues. Some academic suggested that we should have a higher level agency. What's the position of Ministry of Labor? Also for the Director General. The fourth question is the Control Yuan has paid a lot of attention to this issue for many years. And there are also some central alert to many agencies. NHRC was established on August last year. However, the Power Exercise Act has been passed. So the question is how the NHRC can help to tackle this issue. So maybe Director General Shi, could you respond to the first three questions? Let me say that the employers should take care of the migrant workers they hire. For example, drinking water. For example, the halal food for Indonesian workers, and also need to have sufficient space to sleep. The design of fishing vessels that need to meet international standards is 3.6 square meters for the living space on land. That's for the dormitory. If there's any dispute, and we can help to mediate the dispute for those hired domestically. The second question is we need the help of ship owners. Any other administrative measures? The local government will talk to the Fishery Association, and we will also go to those places where the ship owners will gather. We will tell them that they need to buy insurance policies for their workers. And the insurance rate is 76% based on our most recent data. The next question, the line of the responsibility. This is a very big question. You have to go back to look at the executive yuan's organizational structure. It is a much more complicated issue. My office, I'm afraid, cannot answer this question on behalf of the executive yuan. Thank you. Secretary General Shi talked about this issue. The regulator for the offshore migrant fishers is COA, but Mr. Shi, you believe that the Ministry of Labor should be the government authority for these offshore migrant fishers. Thank you very much for raising this issue. Let me clarify from the position of Ministry of Labor. I think the bottom line is that they can help those domestically hired migrant fishers, but for those offshore fishers, migrant fishers, it is not within their responsibility. But, well, there may be some domestically hired migrant workers working on these offshore vessels. So the Ministry of Labor probably need to talk about how we can improve the governance or supervision for those distant water fishing vessels. Ministry of Labor will do everything to protect the interests of the workers. However, we are restrained by the existing laws and regulation, and we have the trade union, and we also work with the Fishery Association, Agricultural Association. We also work with the government. We conduct inspection and audits. It takes a cross-agency team to protect the interests of the laborers. So for the domestically hired migrant workers, this is something we have more control. If we are talking about the offshore, the migrant workers, I think we need the help of the fishery agencies and also the occupational safety administration. So it takes a multi-agency team, cross-agency team. Ministry of Labor plays a part, but we also need a strong partnership. Thank you. Thank you very much, Director General Shi, for your response. Indeed, for Department of Workforce Development Agency or Ministry of Labor, this is a very challenging issue. I know you have divisional labor. You also involve different agencies. Probably need to have the one unified contact window. The last question is for NHRC because we are still working on having the legislative end to pass the Power Exercise Act. NHRC would like to initiate a special project led by President Chen. without the Power Exercise Act in place, but there's still a lot we can do. We need to adopt a process learning by doing. I also have the expectations for the legislative yuan to support these act. Maybe Member Tsai, you can respond to the question. Go to the Article 2 of the Organic Act of the NHRC. It talked about any the matters involving the torture should be investigated by NHRC. So we actually do not need to have the Power Exercise Act. We can just refer to the Organic Act of NHRC. We can initiate inspection and investigation on those suspected cases, as Member Ji just indicated. The NHRC has decided to initiate a special project. So Article 2 of the Organic Act does authorize us to do that. And how about Consultant Wei? Well, you can review the Organic Act. That give us the authorities to do something without the adoption of the Power Exercise Act. But I still think we should have the Power Exercise Act adopted by the legislative yuan as soon as possible. I still remember that some judge said to me that at that time, in the court proceeding, they actually did not talk about the international competence that often. My background is Constitution, so usually in my argument, I will cite a lot of content from the Constitution. You can still initiate such a project, but we'd still like to see the adoption of the Power Exercise Act. The question on the Power Exercise Act of NHRC, I did not have time to talk about this. The Implementation Act of the two international human rights covenants, Article 4, it covers all levels of the government agency, including the control yuan, to protect people's human rights. And Article 4 of the Power Exercise Act also had a similar statement. The ICCPR, ICSCR still give you a lot of authorities to move in this direction. Thank you. As said earlier, we have the Organic Act and also the Implementation Act of the two international human rights covenants. If we do not have the Power Exercise Act, this is a borderline issue. We can do what has been empowered by the Organic Act and also the two covenants of the United Nations. And of course, this is great responsibility for NHRC. This morning, we started our discussion on NPM until the discussion and the human rights of fishermen. I think all of us have learned a lot. And the audience can also know that we then at the NHRC really thinks this is a very important issue. So to conclude, I thank you very much for your participation. Thank you much for your questions, your insights, and the responses. So let me hand over the microphone to the Master of the Ceremony. Thank you very much. That concludes our forum. Thank you.